we have
on
noted.
Jammu Kashmir, my lord. I will kindly see Article 246.
And you get the that Act, Jammu and Kashmir Act also.
I'll just.
So that you can have some idea
I'll
before making any submission on that.
Is your argument that there cannot be a public service commission for union territories may be a very dangerous argument, because you're conceding ground that look, there can't be a public service commission for a union territory.
It is required to be pointed out that the provisions of services are made in chapter 14 of the Constitution having the title Services under the Union and the States. It does not categorically mention union territories. There is a deliberate silence, which will become clear, Manoj, further, that it's not just a coincidence that it is not included. There is a conscious omission. The Constitution, which is fully aware of three units of governance, that is union, the state and the union territory, categorically excludes the union territory from the said chapter under the heading services under the union and the states. In other words, there are only two categories of services contemplated under union services or posts in connection with affairs of the union. In connection with the affairs of the union is the phrase I have borrowed from Article 309 itself. And two, state services or posts in connection with affairs of any state. There is no contemplation of any separate and independent services for union territories, since any union territory, whether with or without legislature, is constitutionally an extension of the union, and not only statutes but the Constitution recognizes the above position as stated above. All India services officers selected by UPSC or a board controlled by the central government are deployed in connection with the affairs of the union territory, since such affairs are necessarily in connections with the affairs of the union. The inevitable conclusion in chapter 14 under the heading services under the union and the state is that it does not apply to union territory, which becomes clear from Article 308 contained in part 14 itself. Lord, the first article, and this is again, Lord, clinching in my respectful submission. At this juncture, it is relevant to note, and you will note this, Lord, this is very, very, very relevant. At this juncture, it is relevant to note that Article 308 of the Constitution was in existence even prior to the insertion of the concept of union territory, which came to be amended by 7th Amendment. Union territory came in 7th Amendment, but 308 was there, by which the concept of union territory is also introduced in Part 8 of the Constitution, and the concept of an administrator to administer the affairs of union territory was also introduced by very same amendment under Article 239. Though Article 308 came to be amended simultaneously with introduction of union territory and the contemplation of an administrator to administer the same, the Parliament did not incorporate union territory within the meaning of the expression state. Lord, this is the amended provision. Lord, kindly see the title, Part 14, Services under the Union and the State, Chapter 1, Services, Interpretation. In this part, unless the context otherwise requires, the expression state does not include state of Jammu and Kashmir. This is the only amendment. Simultaneously, this is a part of 7th Amendment. The Parliament could have said state would include union territories, because elsewhere in other provisions, Parliament has said in the 7th Amendment itself that the word state here would include union territory. Parliament doesn't say, Manoj, in the chapter of services. And please bear one factor in mind. Thereafter it comes, Lord. Kindly see, my Lord, what was the earlier provision which was amended. My Lord, there is an asterisk here. An asterisk, my Lord, is also quoted. It's not my paraphrasing. Substituted by the Constitution 7th Amendment Act, Section 29 and Schedule 4. Earlier, my Lord, it was means a state specified in Part A or Part B of the first schedule. So earlier, prior to the 7th Amendment, the position was in the in this part, unless the context otherwise requires, the expression state means part A and part B states. Delhi was not a part A or part B states. I'll come to that later on. That is one more clinching indication. Then, 309. Recruitment and conditions of service of persons serving the union or the state. Provided that subject to the provisions of this constitution, acts of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed to public services and posts. Please note, in connection with affairs of the union or any state. Those who are working with UNGNCT in Delhi are working for the affairs of the union. Because for this chapter, there is no union territory. Provided that it shall be competent for the president or such person as he may direct in case of services and posts in connection with the affairs of the union, and for the governor of a state. So two things here. Or such person as he may direct in case of services and posts in connection with affairs of the state to make rules regulating the recruitment and conditions of service of the persons appointed to such services and posts until provision, etc. Two things. By this very amendment, there is an asterisk. The word governor came to be introduced. That is 7th Amendment. 7th Amendment also stipulates administrator for union territory. It does not say governor or administrator. Yes. Second, there is second asterisk. Earlier, prior to 7th Amendment, it used to say Raj Pramukh. Now, Raj Pramukh in 7th Amendment is substituted or amended with the word governor. Kindly bear these two facts in mind. Administrator who comes by this very amendment is not included, and Raj Pramukh becomes governor. There is a significance. Para 15. Firstly, not only the recruitment with respect to the person serving in connection with the affairs of the union is exclusively left to the parliament under entry 7 list 1, but their conditions of service is also left to the. There is an occupied field. Those who are serving in the affairs of the union are appointed by the law made under entry 7 list 1. Now, but it cannot be disputed that the term condition of service includes within it posting, transfer, promotion, departmental action, etc. Secondly, there is one unimpeachable indication that the term union territory is kept outside the purview of 309. It is important to note that Article 309 confers the power to legislate an appropriate law and or make rules governing condition of service of persons appointed for the public services and posts in connection with affairs of the union or any state. This makes it clear that entry 41 list 2 can never be made available to union territory as persons appointed in connection with affairs of the union territory are necessarily appointed in connection with the affairs of the union, and the field is occupied by either legislative enactment or any it should be or stroke and I'll change and rules made thereunder, namely under entry 70 list 1, which reads as under the entry under which present regime functions for UT, Union Public Service Commissions, All India Services, and Union Public Service Commission. But all India services, I'll be able to show that from the statutory regime. It is submitted that at this juncture, and elaborated later, that there are 3 tiers of services in NCT of Delhi occupied by public servant appointed in connection with the affairs of the union. All India service officers who are governed by All India Services Act 1951, which is undisputably made in exercise of powers under entry 70 list 1. Then DENIC's employees who are appointed and who are governed by DENIC rules, which are made by the President of India in exercise of rule-making power conferred under proviso to Article 309 of the Constitution. And C, subordinate public servants appointed under DAS rules 2022, which rules are also made in exercise of powers under the proviso to Article 309 of the Constitution, clearly indicating that they are working in the affairs of the Union. Since the field is already occupied by the legislation made under Article 70 List 1 and rules framed under the proviso to Article 309 of the Constitution, and the chapter of services does not contemplate separate services for covering Union territories, the question of examining as to whether entry 41 List 2 would apply to Union territory of Delhi or not may not be necessary unless it is established that Delhi is a state. Delhi is undisputably not a state. But A, NDMC, B is relevant. Constitution's 7th Amendment Act, which introduced the concept of Union territory, made a very significant amendment in the proviso to Article 309 by omitting the word or Raj Pramukh and not introducing the word Union territory. To appreciate this, the following hierarchy of units of governance in India existing at the time of 7th Amendment needs to be understood. There were 4 categories of states, namely Part A, B, C and D, which were having governors for Part A states, Raj Pramukh for Part B states, and chief commissioners for Part C and D states. When 7th Amendment came, there cannot be and there is no dispute that Delhi was a Part C state having a chief commissioner, which became administratable now after 7th Amendment and the Union territory. Now kindly see the proviso to Article 309. Instead of Raj Pramukh, that is Part B state goes, the constitutional amendment says governor, meaning thereby it applies only to Part A states, which are all full-fledged states. The word administrator is conspicuously absent, which was applicable to Part C and D states. They become union territories or some of them merged with other states. The Parliament, while amending the Constitution by 7th Constitutional Amendment, not only not include union territory while defining the expression state under Article 308 of the Constitution and not include administrator in the proviso to 309, but even omitted the reference to Raj Pramukh in proviso to Article 309 and thereby excluded even Part B states from the purview of Part 14, that is services. This inevitably reflects that Parliament very consciously omitted any separate service for Union territory from Part 14, it should be 4 Part 14, under the heading of services under the Union and the states, but even Part B states under the Raj Pramukhs were also kept out of Part 14. So only Part 1, Part A states having governors even before that, big full-fledged states. Now, A and B were merged. They became full-fledged states after the 7th Amendment. So that goes. But another indication. Chapter 2 contained in Part 14 relating to services provides for Public Service Commission, which reads as under 315. But same chapter, services, which reads as under. Subject to the provisions of this article, there shall be a Public Service Commission for the Union and a Public Service Commission for each state. Your Lordships can come to sub-article 4. The Public Service Commission for the Union, if requested so to do by the governor of a state, may with the approval of President agree to serve all or any of the needs of that state. The state can say that UPSC will select, I don't want to have my own service commission. Small states do it for financial reasons, etc. That we don't want to incur infrastructure expenses, etc. Let UPSC decide our role. But kindly see the asterisk, the words or Raj Pramukh omitted by the 7th Constitutional Amendment. Administrator is not added. Though same amendment introduced the concept of union territory and administrator for it.
Though interestingly, the J&K Reorganization Act incorporates a public service commission for the UTs of Jammu and Kashmir.
I will immediately answer that, Lord. I was to come to it later, but since that has occurred to my Lord, the Chief Justice of India. Your Lordship, kindly take the Constitution. There is a clear-cut answer. There is a clear-cut answer. Kindly take Article Lord 239 AA. Your Lordship said Lord 3.
239 AA 3.
AA sub-article 3. Subject to the provisions of this Constitution, the Legislative Assembly shall have power to make laws for the whole or any part of National Capital Territory with respect to any of the matters enumerated in the state list or in the concurrent list, insofar as any such matter is applicable to Union territories. Now, Lord, for the testing the argument, accept my submission hypothetically that services are not. Services fall within this exception of insofar as, and Manoj, specific exclusions. Kindly see B. If nothing in subclause A shall derogate from the powers of Parliament under this Constitution to make laws with respect to any matter for a union territory or any part thereof. So B says that Parliament can, by making law, give powers even to excluded categories to the union territory. I hope, Lord, I am clear. A restricts the power of union territory. 1, specific exclusions, 3 in number, and second, implied exclusion if it falls within insofar as such matter is applicable. But Parliament can say that no, we may even give police power to one union territory. That is B. I'll again read. Nothing in subclause A shall derogate.
239A is only applicable to Delhi.
Delhi, not the
Delhi only.
Kashmir.
You have to.
I'm saying that. I'm saying something else. Nothing in, tomorrow, kindly see,
What 239, this clause 3B says is that in relation to Delhi also, Parliament can legislate even on the state list.
Exactly, I'm saying, that's what precisely I'm saying. Parliament can say that for NCT of Delhi, there would be a separate state public service commission, or there would be, even police will be under the Delhi administration.
So according to you, the Parliament, while enacting the
State Reorganization Act is a parliamentary law.
they can always delegate, they can constitute an institution such as a public service.
Yes. Lord, that is number 1. Number 2, kindly see, my Lord, Article 4.
It's the union which constituted.
Union.
Constituted.
Which
Yeah,
constitutes
Jammu.
earlier, kindly see, Jammu and Kashmir again is a sui generis, Lord. Example, there was a state public service commission. For good reasons, Lord, which are not relevant here, they were bifurcated into 2 union territories. So the Parliament wanted continuance of the Public Service Commission, but leaving it at that, Parliament can, and Parliament did, by law, said that there are no restrictions. You have your own Public Service Commission. That can be done to even Union Territory of Lakshadweep. Parliament can say that you have your own Lakshadweep police service, or your land issue is also given to
Right, but if Parliament is constituting a public service commission for a union territory, which is a power which Parliament exercises under which entry?
Article 4. Article 4. Article 4, not sub-article 4. Article 4. Kindly see them. Article 4. But first, kindly see 3.
Oh, the question is
Formation of
that the constitution of the service commission in the state of Jammu and Kashmir, if it is in exercise of the parliamentary power, or did the state legislative assembly has exercised that?
Parliamentary power. It is,
How is that, if that is the case, then how is that relatable to Article 4? Not relatable to. Sure?
first, can you see 3?
Yeah.
It is Parliament made state reorganization. First of all, it's not after UT of JNK, there is no legislative assembly as of now. So the question of assembly making would not arise. Parliament may by law form a new state by separation of territory from any state, or by uniting 2 or more states or part of states, or by uniting any territory to a part of any state. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either House of Parliament, except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its.
But I tell you the problem with this submission. Parliament under entry 70 of list 1 can regulate to constitute, legislate to constitute a Union Public Service Commission. So under entry 70 of list 1, they cannot constitute a Public Service Commission for a Union Territory. Entry 41 of list 2, according to you, refers to a State Public Service Commission. That will not apply to a Union Territory.
Which
That means
unless
that
Parliament
means-
agrees.
No. Therefore, even Parliament cannot legislate under entry 40 of list 2 to constitute a Union Territory Public Service Commission. So there is neither a power in Parliament to do that under entry
I'll
70,
answer this in
nor is there a power under entry 40 by virtue of your argument which takes away that power, because that is not a power which is relatable. It doesn't apply to a Union Territory.
Would your lordships again see para 4, Article 4? And taking taking their argument at its
Maybe
best.
still an answer to it.
No, I'll
Which
not
is,
say that.
no, I'll tell you, possibly there's only one way to answer it, and which is to say that though Parliament does not have an express power either under entry 70 or entry 41 of list, entry 70 of L1 or entry 70 of list 2, Parliament will rely upon, the ragbag, as Justice Venkat Chalaya called it, under entry 97. That's the only way to
There are 2 answers.
break the conundrum.
There are
Parliament
2
cannot
answers.
rely upon anything which is not specifically conferred is vested in Parliament.
There are 2 answers. Kindly read along with me once again Article 4. Any law referred to in Article 2 or 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of the law, and may also contain any such supplemental, incidental, and consequential provisions, including provisions as to representation in Parliament and in legislature of or legislatures of the state or states affected. No such law, this is Reorganization Act, shall be deemed to be an amendment of this Constitution for the purpose of Article 368.
That
So
will
maybe
not help
Parliament
you.
amended the Constitution.
That will not help you, Mr. Sultan. A first schedule only deals with the territories of the states. What is the territory? Territorial extent. Fourth schedule deals with the Council of States.
Leave the territory.
So when
Read
it gives
further.
you supplementary powers, that's in relation to the first schedule and the fourth schedule. That will not. Possibly the only way to save this is to say entry 97.
Mr. Mehta, yes. See what is pointed out to you. Union powers are under entry 70, list 1. The state powers are under entry 41, list 2.
My lord.
There is no specific, because entry 41 may not be applicable because it is with respect to state. And even as per the Constitution bench judgment also, correct? Union territory is not, it is not a state. So entry 41 may not be applicable so far the Union territory is concerned. But the question which is posed is under which provision of law with respect to the Union territory, correct? The Union Public Service Commission shall be applicable.
State
Would your
state public service.
State public.
Would your lordships come to Article 246?
Because earlier you said that entry 41 shall not be applicable at all because it is not a state. Because it is under Article 239AA, it is a special power, hybrid power which is given, which is not equivalent to state at all. Therefore, to apply entry 41, correct, will be erroneous.
My lords.
Then under which provision, correct, it will be applicable. That is what you have said, Article 302, 3 services, A, B, C, correct, different, all these things that we have
I'm on
noted.
Jammu Kashmir, my lord. I will kindly see Article 246.
And you get the, that act, Jammu and Kashmir Act also.
I'll just.
So that you can have some idea
I'll,
before making any submission on that. Under which provision, under which powers that law is
Lord,
enacted.
I'll definitely, my lord, apply myself to that and my lord respond.
Because you will immediately get in exercise the powers under so and so, or in exercise the powers. Immediately you can get from that act.
I'll just not get it, my lord, but put your lordship, I'll come to it, my lord, a little later, my lord. I'll apply myself, but please see 246.
That it's covered by 246(4), that Parliament can legislate on any matter on respect of a territory which is not in a state.
And even enumerated in the state list. Kindly see, my lord, Parliament has power to make laws with respect to any matter for any part of the territory of India, not included in a state, notwithstanding that such matter is a matter enumerated in the state list.
So it is Parliament's legislative powers with respect to union territories.
Yes. So, Parliament can exercise the powers under entry 41 list 2 for this territory, because when the reorganization
No,
act,
that will not help you again, because look at the last part of this 240. Notwithstanding that such matter is a matter enumerated in the state list. So even if a matter is in the state list, Parliament can still exercise power on that area for a union territory.
that's what I'm
This is
saying.
not even in the state list according to you.
No, 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 no. No, my lord,
Whether also the fact that 246 falls under chapter 1 of part 11, which is relationship with
kindly see, my lord, kindly read it again. Kindly, my lord, read it again.
Mr. Mehta, the answer possibly to my question is that this will only be relatable to entry 97 of list 1. Any matter not enumerated in any other list.
any other.
That is, my lord, that can be the answer, my lord, but my lord, again, my lord.
Yeah.
If you have got,
I'll respond.
if you have got any
reflect on
action,
it.
subsequently you can
Reflect on it.
clarify and reflect.
Yes, my lord, but one.
All right, let's go to
one
para
submission.
25.
My lord, even if my learned friend is right, that would mean that provision in the Jammu Kashmir Reorganization Act may be bad in law. That would not mean that the Delhi would have the legislative power to have.
That you have so said in the earlier, that they have to show under which provision their services are falling within the.
Falling.
Yeah, that is what you have already said.
Yes, but
The only point is your argument that there cannot be a public service commission for union territories may be a very dangerous argument. Because you're conceding ground that look, there can't be a public service commission for a union territory.
unless the Parliament permits.
All
Well,
right,
that's
para
the
25.
constitutional.
Let's see para 25.
And my lord, your lordships, Article 315, which provides for commission, UPSC and the State Public Service Commission, my lord, uses the word governor, not administrator. And this amendment comes simultaneously. It could have said governor or administrator as the case may be. This is constitutional silence. A deliberate silence, when I use the word deliberate silence, because both came under the same amendment, 7th amendment. 315 is also amended. Union territory as a concept is inserted and administrator is defined for the first time by the very same amendment.